This is Michael Bistro. Michael Faces Market and Bistro. This is Michael Market and Bistro.com. That's out of the line system. We got the latest cases for the table of contents for the Chief Supreme Court tax law derby for Downs and Racing is Down Racing. This cabinet Sega showed that the movement of Crossroads, 3 legal reforms needed now. This is Marcel Hummel, Professor, Resident Senior of Program and Research, Religion, University of Pennsylvania, explains how the Kavanaugh confirmation process shows crossroads, which Me Too movement no stands. Hamilton goes to describe 3 legal reforms needed now in fixing criminal civil statutes, limitation, revised defamation laws, and fixing mandatory reporting laws, those knowing of sex assault sheriffs and authorities. This is the Gaming Opinions, Down Racing LP, Pennsylvania Court, Supreme Court, Pennsylvania, docket number 70 and 71, map 217. Opinion date is October 25th, 2018. Judge Thomas G. Saylor. Areas of law, gaming law, government, administrative law, tax law. Issued before Pennsylvania Supreme Court in the matter of this whether sales or use tax must be paid in relation of 2 distinct items. Purchase of closed-circuit horse racing simulation systems, and the payment of royalties for intellectual property used for conjunction with the operation of video poker machines. For the taxpayers' off-track wagering locations use video poker machines, taxpayers entered into the service contract with Teleview Racing Control Inc., pursuant to which Teleview supplied equipment such as screens, satellites, dishes, closed-circuit television feeds. These items used provide live display at each television feeds. These are used to provide live displays at each OT facility, which occurring the Puckman Downs and other tracks across the country. Televiews provide equipment for the system, and agreement also supply personal installment, maintain, operate equipment that relates in video poker games. Tax purchased machines from Interline Gaming Technologies PLC, in which the tax of which are included accordance to a separate intellectual property agreement, and taxpayers also paid IGT loyalty fees. To maintain and operate equipment in relation to poker games, taxpayer purchase machines from International Gaming Technology PLC IGT, on which pay taxes are distributed according to which separate intellectual property agreement. Taxpayers also pay IGT royalty fees for intellectual property associated with various different themes. Different poker games would run the machines. Poker Pennsylvania Department of Revenue audit. Taxpayers accept approximately $34,000 on paid sales and taxes, usually stemmed from taxpayer payments or review under their secure contract. And challenging assessment, taxpayers include that a number of $13,000 in taxes and payment and royalty fees. IGT thus refund those monies. Department denied relief. Taxpayers sought review of both matters. Commonwealth Court. Decision of Appeals. The court found television consolidated taxes and non-taxable charges and non-invoices. Panel thus conclude that taxpayers had failed to present documentary evidence specifying which portion of the billed amounts were non-taxable As required, department regulations, court also injected taxpayer requirements, paid IGT royalty fees. Pennsylvania Supreme Court reversed in the Commonwealth. Courts ordered to ensure the Board of Finance and Revenue. All royalties were paid on softwares as well. Election law, October 26, 2018. Table of Department of State and Halifax election law. Florida Supreme Court. Kavanaugh site shows the common crossroads and program of research for the University of Pennsylvania. The Kavanaugh confirmatory process crossroads with the Me movement. Fixed criminal statutes of limitations, defamation laws, and matters reporting laws and knowledge. Department of State Hollander Court, Florida Supreme Court docket SC 181366, SC 181367, October 20, 2018. Judge per crim, areas of law, election law. Supreme Court reversed the judgment of circuit invalidating the enjoined Constitutional Revision Commission revision designated in Amendment 6 entitled Rights of Crime Victim Judges for the Placements of the Ballot, holding that clearly and consecutively can demonstrate a ballot title or summary were misleading and did not reasonably inform voters to achieve purpose of Amendment 6. The circuit struck Amendment 6 for the ballot finding the ballot summary and the title of misleading. Supreme Court vacated the circuit court's injunction holding the lead read together the title and summary reasonable inform voters' chief purpose affect the purpose amendment, namely that they can create victims' rights would require de novo report to agencies interpretations and statutes of rules that would raise judges and justices' mandatory retirement age. It would no longer allow competition in judicial term and one half or the term that already have served by the retirement age. There's 63 different newsletters covering different practices area, covering every federal appellate court and highest courts in the United States of America daily. Aviation, October 26, 2018. Table of Precision Aeromotive Corps. Personal Injury Products Liability Used Courts Appeals in Third Circuit. Kavanaugh shows that movements at crossroads. Aviation opinion. SIKKELE versus Precision Aeromotive Corps. Court, U.S. Court of Appeals, Third Circuit, docket 173006, October 20, 2008. Judge Pat Switz. Area Law, Aviation, Personal Injury Product Liability. And this is SIKKELE was killed on an aircraft piling crash after taking off in North Carolina, Transfer County Airport. Aircraft was long-coming engine sickly widowed, allegedly. The aircraft lost power due to the detected decision of the engine and carburetor. The FAA had an incoming type of certificate from the engine, certified the design performed properly, satisfies federal regulations. SIKKELES widow brought strictly liability claims against long-coming alleged design defect. The Third Circuit held SIKKELES state law claims as their bared-based doctrine and filled presumption, and the district court concluded that claims are in conflict. Prompt and Luke Cumming was entitled summary judgment and on the SIKKELES strict liability and negligence claims are based on Pennsylvania law. The granted Luke Cumming summary judgment. The SIKKELES claims that Luke Cumming violated 14 CFR 21.3 by failing to notify the FAA allegedly defect, the child circuit reversed in the part rejecting argument in the SIKKELEAS claims conflicting and FAA regulation made it impossible. Newcoming unilateral implement design changes in Pennsylvania law allegedly would have required. Newcoming was incriminating evidence on FAA would not have any allowed design set forth on a type certificate. Summary judgment, SIKKLEA strictly liability negative claim was inappropriate. Inappropriate because of the genuine dispute of material fact concerning summary judgment, property of failure to notify the FAA claim. Hiller versus Hiller. South Dakota Supreme Court, October 26, 2018. Kavanaugh's sake shows a movement in crossroads. South Dakota Supreme Court, Hiller versus Hiller, citation 2018, South Dakota 74, October 24, 2018. Judge Salter, areas of law, family law. Supreme Court affirmed that the reverse remand that part decision circuit ordered appellate pay attorney fees incurred for the former spouse appellee holding the circuit of abused as discretion order appellate pay expert witness fee related to the appellate motion and chance that Kessie specified and held at the circuit court. Did they clearly err in finding appellate contempt? Did not abuse the discretionary award attorney fees incurred and the contempt action. Did the abuse of discretion award appellate attorney fees, abuse discretion order appellate pay expert witness fees related, appellate motion for change of custody. To start, the Department of State versus Hollander election law, Florida Supreme Court. Department of State Hollander, Florida Supreme Court, SC18-1366, SC18-137, October 25, 2018. Election Law, Supreme Court Judgment Circuit invalidated and joining Constitutional Revision Commission Revision 1, Design Amendment 6 entitled Rights of the Crime Victims Judges for Placement Ballot Holding Clearly continuing to demand ballot and summary to misleading by reasonable informed voters. Chief Purpose Amendment 6. Brian Pippin versus Sun State Oil, INC. Business law, contracts, real estate, property law. The Supreme Court of Alabama. Brian Pippin versus Sun State Oil. Sunset Acres and Olson Properties, Othello, Washington, Kennewick, Washington. Brian Pippin, that's the twin towers that are inside the Olson Properties, which is in my first and last name, Felix Barela, that's South Dakota. This is Bach at 1160850, September 21st, 2018. Judge Marion, areas of business law, contracts, real estate, property law. Gravel pit, gravel is not theirs, and rock crusher ain't theirs either. Gold mine ain't theirs as well. Brian Pickering appealed circuit court grant summary judgment in favor of Sun State Oil. Pickering claimed conversation negatively on witness and trespass of regard of Sand State removal of gasoline pumps from Pickering's property. IMS Partners LLC. IMS purchased some Williams Side Rivers partial property located at 1506 Highway 34 North, Bucks, Alabama property, and which was a situated convenience store gasoline station. IMAS intend to operate Business Bucks County store, Big Buck Canada Big Buck magazine, and that's the Big Buck magazine, the biggest bucks in the world. Anticipation including, and this is the crossroad from also Eugene, Oregon, also Wisconsin, also the crossroad, and also the Amtrak station, that the shipment of all military access, military vehicles, off-land, rover, and also amphibian, and also interest in aviation into the University of the Vault and Chase Bank, which is the biggest compound facility for fueling. And you can't move the fuel lines because they've already been moved in access and exporting, importing for moving communists, criminal convicts, and any criminal activity U.S. citizens. And this is called Buck's Country Store. That's Findlay, Washington, Congress alumnus, and called Tater Boy, T-A-T-E-R-B-O-D-Y. And these are no exceptionals accepted on the property line. As you can see, these black minorities kicked out of Pasco, Kennewick, and Tri-City area, moved into cremator, and they were put in the cremator because they had no place to go, no place to put them in gurney sacks, and put them in body bags, and put them in these small plastic bags, and put them inside a facility with the Jews, and that's J-E-W Jews, that were flooded out on the administration office, and that's Adolf Hitler's property line. Business of Bucks and Country Store and Stipulation of Course and Property, IMAS entered on petroleum supply agreement with Sun Stables Ranch and Farm and Home Administration Office, Big R North 40, first name, last name, still own it. Sun State supply gasoline sell every service group. And this see on the PSA store provide the Sun State the oil lines, fuel lines at Pasco, Burbank, Washington. These leased gasoline pumps IMs 10 years, or liquor, plutonium, and marine pool moved to Texas and also Richland, Washington. These are formats. They got a 10-year exchange. These statute of limitations expired long time ago, and the property lines are still existing. And these IMS 10 years exchange called IMAS, purchase minimum of 6 million gallons of petroleum for fund Sun State over 10-year term. This point of 2012, Sun State stopped business in IMS because they heard the store was making money would go to the foreclosure. That was called Eagle Escrow, now Escrow Identities changed. That's Dano Law Firm here in Moses Lake on Broadway, Washington. The 2012 Sun State stopped doing business IMS because they heard the store making money. They would go into foreclosure. Sun State reclaims gas pumps immediately allowed to scrape trail, new tenant and retained store customer. They still don't own it. It's not for sale. Rivers executed vendor land deed conveying property Pipkin District William Rivers made clear they've negotiated sale property of gas pumps will include purchase price. 2004 Sun State because they're concerned about vandalism and vandalism and in the property of dedicated retrieve pumps and offering reinstatement pumps reinstatement upper over it will eventually open a doorway for the Senate from the Senate office for more convictions. Just setting these guys up, and they don't even have ownership to it. Pipkin property dedicated retrieve pumps offering receiving once Pipkin retenant and operate on the store. The Sun State disabled the return of the pumps, however, payment sums against Sun State pumps. Alabama Supreme Court found the evidence that Sun State filed UCC1 financing statement for purchase the property. Sun State unperfected security interest in gasoline pumps prior payment. They don't even own it.